Facility compliance failures are no longer internal problems. For most of the last several decades, an environmental violation at an industrial facility followed a fairly predictable arc. Regulators found the problem, a penalty was calculated, the company paid it, and the matter settled within the regulatory relationship. Neighbors might never know the specifics. Lenders rarely asked. A future permit application at the same site would proceed largely independent of what had happened before. That model has been eroding for years. In 2026, EHS teams that still operate on its assumptions are managing risk that no longer fits inside the box they're using to measure it. A set of converging changes in public data access, federal criminal enforcement posture, state-level penalty law, lender due diligence standards, and permitting criteria has fundamentally altered what a facility-level compliance failure actually costs. The fine is increasingly the smallest part of the exposure. The federal enforcement picture shifted in FY 2025. The EPA's fiscal year 2025 enforcement results, released in March, contain numbers that EHS professionals should understand. The criminal program opened 187 new cases, charged 156 defendants, the most since 2016, and produced more than $600 million in fines, restitution, and court-ordered relief. Forfeiture exceeded $1 billion in illegal proceeds. Two cases from 2025 are instructive for what the agency now considers criminal rather than civil matters. The J.H. Baxter companies and their president were sentenced in April 2025 for routinely and illegally evaporating hazardous wastewater at an Oregon wood treatment facility for years, knowingly venting hazardous air pollutants into the atmosphere. The court imposed a $1.5 million criminal fine and sentenced the president to 90 days in prison, followed by a year of supervised release for being aware of the practice and lying to conceal the illegal activity from state regulators. Knowing concealment of an environmental violation, not just the violation itself, drove the criminal outcome. In the same fiscal year, Hino Motors paid a $520 million criminal fine after pleading guilty to falsifying emission certification data, plus a $525 million civil penalty, with an estimated $300 million in additional mitigation costs. The underlying issue was false reporting to regulators, compounded over time. The pattern across both cases is the same. The violation was serious, but the concealment and the inaccurate reporting to regulators transformed what might have been a civil enforcement matter into criminal exposure. In December 2025, EPA shifted its stated approach. On December 5, 2025, the EPA's Office of Enforcement and Compliance Assurance issued a memo to enforcement staff announcing a return to what it calls a compliance-first orientation. The memorandum signals a shift in EPA's approach to federal environmental enforcement, namely, by prioritizing the use of compliance assistance tools to bring regulated entities back into compliance rather than pursuing aggressive, protracted enforcement actions. On its face, this sounds like regulatory relief. In practice, what it means is more nuanced for facilities with unresolved issues. The self-audit policy under Compliance First encourages regulated entities to find and fix their environmental noncompliance in exchange for substantial civil and criminal penalty protections if certain criteria are met. Those protections are available to facilities that voluntarily identify, disclose, and correct violations. They are not available to facilities where violations are discovered by regulators before self-disclosure, particularly for repeat violations or where there is evidence of knowing concealment. The practical implication is that the current enforcement environment is more forgiving to proactive disclosure and more consequential for passive or reactive compliance management. For EHS teams operating facilities with unresolved issues or deferred maintenance, this distinction matters. 650,000 people used ECHO in FY 2025, EPA's Enforcement and Compliance History online database, which tracks inspection, violation, and enforcement records across the Clean Air Act, Clean Water Act, and Resource Conservation and Recovery Act for more than 800,000 regulated facilities, is not a niche tool for regulators. The ecosystem had over 650,000 users engaging in over 1.5 million sessions in FY 2025. EPA has also recently added a pipeline view connecting violations to their discovery activities and any enforcement actions taken, making it easier to understand not just that a violation occurred, but what triggered its discovery and whether enforcement followed. Neighboring communities, environmental advocacy groups, journalists, and local elected officials all use this database. So do lenders and insurers. A violation that was resolved 5 years ago through a consent agreement and a modest penalty remains in the record, searchable by anyone with an internet connection. When a facility appears in a new enforcement action, that prior record is visible to regulators who explicitly weigh repeat violations in penalty calculations and to everyone else looking at the same public data. Lenders now treat environmental history as a credit variable. The integration of environmental compliance data into lending decisions is not new, but it has deepened. Environmental contamination or perceived environmental impacts can decrease marketability and property values, complicate conventional financing options, delay or complicate site development and use, slow and potentially jeopardize future sale or development, and introduce the potential for regulatory and third-party legal liabilities. Phase 1 environmental site assessments have long been standard in commercial real estate transactions. What has changed is the scope of what lenders consider. Commercial insurers are evaluating businesses based on their loss history, sustainability practices, and climate mitigation efforts. Compliance history at a specific facility, accessible through ECHO, is increasingly part of that evaluation. For companies seeking project financing for facility expansions or acquisitions of sites with prior enforcement history, this means the compliance record is not just a regulatory matter. It surfaces in the deal structure. State legislatures are formalizing community accountability. Minnesota's 2023 environmental enforcement legislation established a model that other states are watching. When fines exceed $250,000, 40% of the penalty is directed to the community affected by the pollution. The Todd County Community Health and Human Services Department received $1.2 million from the $3 million penalty assessed in the Central Byproducts case, money that will fund health and environmental projects determined by the community itself. That law does something structurally significant beyond the redistribution of penalty dollars. It makes the community a named stakeholder in enforcement outcomes that used to resolve entirely between the regulated party and the regulator. The community now has a formal record of harm and a financial stake in the process. When a facility returns for a future permit modification, or when residents file complaints about ongoing conditions, they carry that history with them. The penalty calculation is no longer just about the violation. The EPA uses a formula that combines the gravity of the violation, potential for harm, and the economic benefit the company gained by failing to comply. As of January 2025, Clean Air Act violations can reach $124,426 per day per violation. That per-day accrual means that the gap between when a violation began and when it was corrected matters enormously to the final penalty number. Facilities that deferred maintenance, delayed corrective action, or allowed violations to persist for months or years face a calculation that compounds against them. What EHS teams should understand is that the penalty calculation is designed to recover not just the harm done, but the money the company saved by not complying in the first place. Regulatory delay is not a cost deferral. It is a liability that accrues at a rate set by statute. The perimeter has expanded. The shift happening across enforcement agencies, state legislatures, public databases, and financial markets is asking EHS professionals to answer a harder version of a familiar question. It is no longer enough to know whether a facility is in compliance today. The question regulators, communities, lenders, and insurers are now formally asking is what the compliance history looks like, how accurately it has been reported, whether internal systems are designed to surface problems before they compound, and whether the organization responded proactively when issues were identified. For facilities where maintenance deferrals and deferred corrective action have been treated as manageable risks, 2026 is a reasonable time to reassess that posture. The consequences of a compliance failure have expanded well beyond the regulatory fence line, and the tools to track that history have never been more accessible to the people who now use them. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.